Hello. Welcome to our estate planning webinar. We are going to get started in just a few moments. At this point, I'm going to give a little bit of time for people to join the webinar and make sure that you are able to hear me and see me okay. So if you can put in the chat, if you can hear me, that would be amazing. If you can see the screen, lets me know that you're there as we see people joining. Hello. So if you're just joining, we're going to get started in just a few minutes. We're just waiting for everyone to join the webinar. We'll get started in just a moment. If you have not already done so, please make sure to download the estate planning workbook that we're going to be going through today. I'm going to go ahead and put that in the chat for you. Okay, it looks like we're getting some people joining us. So we're going to get started in just a moment. So again, if you have not already done it, please make sure to download that workbook. Okay, I'm going to post the link one more time here for the estate planning workbook that we're going to be going through today. I see we have a few people joining us here. Hello. Thank you for commenting in the chat. It's always wonderful to see where people are joining us from. So if you can put the location you're joining us from. Looks like we have Woodland Hills. Hello from Woodland Hills. Ventura. Hello in Ventura. San Diego. Rancho Cucamonga. Looks like we have LA. Hello. Okay. Let's go ahead and get started. So my name is Crista Hermance, and I am an estate planning attorney. And today we're going to be talking about estate planning. Our firm is Hermance Law. You might know us on social media as estate planning mom, estate planning dad. I started the firm about 10 years ago now, with really the goal to have a very family-oriented practice. And at this point, I feel like we really do have that. Our team is very close. And for us, it's really about making sure we have that balance between being able to have the balance of managing our home life as well as our work life. And we really do, I think, do that well as a team. Okay, so our agenda for today, I'm going to share some real life scenarios for you. I'm going to talk about what probate court is. Does anybody have any experience with probate court? If so, please put in the chat court. It's always good to know what people's experience are. Even though this is a webinar, using the chat is a feature that's going to allow me to really get some feedback from you as we go through this, to be able to get ideas of what your experience is, and just other answers to questions that I may have. So please make sure to use that chat for as much as you can when we come to questions. We're going to go through that estate planning workbook that you have. I'm going to talk about how much estate planning costs, the discount for having a trust plan with us, the next steps to get started, and as a bonus, there will be a free advanced healthcare directive if you stay until the end of this webinar. And this is going to be something that we're going to talk about as a very important estate planning document, but it is an option for you to get as a free document for staying till the end. If you have any questions at any point, please feel free to to put it in the chat. If it seems like a good time at that point to be able to get to it, I will answer it then. If not, if I do not get to your question, I will try and save time at the end to be able to get through some of those questions. And then it may not be something that I can answer necessarily online, so we might be able to respond in comments to you throughout the webinar. Okay? Okay. So, first question for you. Do you have any estate planning documents legally in place right now? So, a healthcare directive, guardian nomination. If you have anything, please put in the chat. Yes, right? I want to know if you have any legal documents right now. And again, this is something that you know where the documents are. It's not something that you might have done and you're not really sure where they exist. It looks like we don't have anybody that has estate planning documents on right now, which is totally normal, right? I might get a few that join that have something, but it is completely normal for you to have no estate planning documents and be on this webinar. You are in the right place to learn about what you may need, okay? Okay, so I'm going to go through those scenarios. And these are 4 things, these are cases where proper estate planning could have prevented these situations from happening. Okay, so the first one is an investment account and divorce. So this was a case where our client's sister had passed away, and we were going through probate court with our client, where at this point she was in the process of gathering all of the assets from her sister's estate. And as she's going through it, she comes upon this investment account. So she sends the paperwork to the investment company, and they respond, said, we're so sorry, but we already distributed these assets to the beneficiary that was listed on the account. So the client calls me and says, how is this possible? She had no living heirs. I was her only sister. What could have happened? And so I called, and come to find out that the beneficiary that was listed was the deceased ex-husband, and they had been divorced for over 20 years. It was not an amicable divorce, and she just never updated her beneficiary designation after she had gotten divorced. And the only thing that we could think of is that when the divorce happened, in the divorce decree that says that she got that money, that she thought that that's all that she had to do. So if you take away anything from this, it's please make sure to check your beneficiary designations to make sure that it is the people that you would actually want to receive for any of the accounts. Okay, had the deceased, our client's sister, gone through and completed her estate plan, she would have seen that she had not updated that beneficiary designation and then been able to update it, but she never got to it, right? She never got to getting her estate planning done, which is why we were going through probate court for her. Okay. Okay. Next, we have minor children and life insurance. So I was working at a community event, and as I'm sitting there and talking to this mom, and she's got 3 little girls with her, and as we're talking, the mom says to me, she says, I recently lost my husband. And I said, I'm so sorry to hear that. How are you doing? And she said, well, at this point, I'm doing a lot, but it's been really hard. Luckily, my husband had this life insurance policy for us. And I said, that's great to hear. How is it going for you with the life insurance policy? And she said, well, for whatever reason, my husband didn't list me as the beneficiary in the life insurance policy. He listed 3 minor girls. How is that going for you? Because I, as an estate planning attorney, know kind of what road this is going down. And so I asked her, and she said, well, for whatever reason, I have to go to court and prove that I have guardianship over my children to be able to get this money released from the life insurance company. And I said, are you going through that process? And she said, I just don't have the mental capacity to even deal with this right now. And so she had this very large life insurance policy that, her husband had gotten in this exact instance that if something happened to him, her and her kids would be taken care of, and she has no access to this money. And so in California, minor children can't actually inherit money or property. And so, in order for the mom to get this money, she has to prove guardianship through the court that the life insurance company would then use to be able to release that money to her, whether it be to her or into a blocked account. And and I asked her, I said, did you and your husband ever do any type of estate planning? And she said, it had always been on our to-do list, and it had just been something that we never got to. And I hear this so often from clients that this is something that they've meant to do, right? That they've been meaning to do, and it's just something that just to the side. And this is the perfect example where having gone through that process and doing an estate plan really would have been able to open up the eyes of what actually happens with life insurance when it comes to minor children, and making sure that it's set up the right way to make sure whatever your intentions are done correctly. Okay. Okay. If you are just joining us and you're late, I want to make sure to get that workshop or the workbook in there just so that you have it when we get started. I'm just going through some scenarios right now. And again, if you have any questions, please feel free to put those in the chat as I'm going through these. Okay. Next, we have adult sibling and parents home. This is a call that we get fairly often where where parents pass away, right? And so the adult children will call in and say, it's parents just passed away, I don't really know what to do. In this case, my client was the daughter, and her mom had just passed away, and she said, it's just me and my brother, all my mom had was her house, can you just please transfer the house to me and my brother? I said, let me do a little bit of research on the property and see what's going on. And so I pulled the title and found out that the home was owned in mom's individual name. And so I called the daughter back and I said, unfortunately, we have to go through probate in order to be able to get this house transferred to you and your brother. And so it ended up taking almost a year, and it cost them about $18,000 in probate fees. And at the end, we were able to get the house transferred to her and her brother like she wanted. And this all could have been avoided, right? If mom, who had this $800,000 home, had a revocable living trust, and we're going to talk about what a trust is. Had she had this trust and had her home in the name of the trust, when daughter called me, that conversation would have gone completely different. We could have got it done at a fraction of the cost in a fraction of the time, exactly how mom and daughter wanted it, just transferring it to her and her brother. And that's why estate planning is so important, because here, in just an average family, and with mom just owning a home and having no other assets, a trust would have saved this family so much money and the stress of having to go through probate court. Okay. Okay. Last one scenario that I have for you is the blended family and the unintentional disinheritance. You hear a lot of these stories, I'm sure, where somebody gets remarried and then somebody passes away and now assets aren't going to the kids as intended. And that is really what happened here. So my client, her mom, she was the only child, great relationship with her mother, got remarried very late in her life. And for whatever reason, mom added her new husband to title to the family home. And this was the home that my client had grown up in. They'd owned it her entire life. And she added her new husband to it. But mom passed away very unexpectedly and had no estate planning documents in place. And if you can guess what happened next, yes, the new husband got the house. And because it went to him how title was set, it just automatically went to him when mom passed away. And so you can understand from my client's perspective, she was devastated that the family home was going to this new husband. So this is where I call it an unintentional disinheritance, because had mom known the ramifications of doing this deed, and something that she did online, she got it recorded, and she had no legal guidance on what she was doing. She unintentionally disinherited her daughter. Her daughter received nothing from this property, and so the daughter sued, um, and it went on for several years, from a court perspective, and in the end they did end up settling, so my client was able to get some money out of it. But the emotional stress that she had to go through, was all things that could have been avoided had mom done some type of estate plan, right? Whether it would have been a trust or a will or something with what her intentions were. But here, all she had done was the deed. And so she, didn't necessarily understand or know what was going to happen as a result of it. Okay. Okay. Um, Again, if you have any questions, please feel free to put those in the chat. What I would like to do now is, I want you to really just think about, what are you trying to accomplish with estate planning? What is important to you? And really keep that in mind as I'm going through these questions, so that it keeps it top of mind, so that you can get to the point of why you're here, right? Why are you watching this webinar? What is important? What are you trying to solve? Okay. So let's talk about what happens when you don't have a plan in place and something were to happen to you. Okay. There's three areas that we really look at. The first is if you have minor children. And so minor children in the state of California, are anybody that's under the age of 18 would be a minor child. Um, and it's important that if there's no plan in place, then it would be that guardianship would have to be done for those minor children. And so somebody, generally a family member or a friend, would petition the court for guardianship of those kids if something happened to both parents. The problem with this, with having no plan, is that there's nothing legally in writing that tells the court who you want to be guardians of your children, which also means that the court has no idea who you don't want to be guardians for your minor children, right? And so they're making a decision without any input from you. Next, we look at incapacity. And when we think about incapacity, doesn't have the mental ability to really understand what happens as a result of signing this document, right? If I sign this deed, do I understand that I'm giving this house to this one child, right? It's, we see this in people. Maybe they have had a stroke, or there's Alzheimer's or dementia, or something where they're in a coma, right? Maybe there's something that's medically happened to them that they can't make decisions on their own. And so this is where a court's conservatorship would come into play. And we see this for a lot of our clients that come in, where we have adult children that have elderly parents, and they don't have any estate planning documents in place, and they need to sell the house, right, to be able to afford to put them in an assisted living facility. There is what is a court conservatorship. That's where the court's saying, okay, this person is petitioning the court, now has legal authority to make financial decisions or to make a medical path. The problem again with this is the court has no idea who you would want in this role, right? And so the court's making a decision where the family could be fighting. I've seen a lot of these issues. Where they can't agree on who is going to be best to take care of or to make decisions in that role. And again, because they don't have the capacity to tell the court who they want, the court's making that decision without any of their input. Okay. The last thing we look about is when somebody actually passes away and there's no plan in place. This is where probate court comes into play. So probate court is the process that when you own assets in your individual name, any of those assets then would have to go through this process. So generally you would have a family member or somebody as an agent that would come forward and petition the court for probate. Then they would get approved for probate to basically get letters saying that they now have the authority to start gathering all of these assets together. During this process, generally a bond would be required. It's also going to make sure that there is creditors that are notified. There's publication in newspaper. These are all things that during this whole court process is going to occur. Generally in California, it can take anywhere from 1 to 2 years for a probate proceeding to actually, from start to finish, be completed. And at the end, once all of the bills are paid, attorney's fees, personal representative fees, then everything is then distributed to those heirs or beneficiaries of the estate. Once people understand what probate court is, that generally they want to avoid it. And the reason or the reasons are, one, it's a very long process, like I mentioned, 1 to 2 years, which means if you have a breadwinner of the family that maybe has all the accounts in their name, they were the one that was earning the money, and now nobody else has access, those accounts are essentially now a part of the probate estate. And so it can take 2 years for the family to even gain access to those funds. Probate is a public court hearing, which means anybody can go to the courthouse, pull records, and find out what you owe money, who you owed money to, and who your beneficiaries are. And so this is a lot of times when clients, they want to avoid probate. It's because they don't want all of their information out. And the last thing is that probate court is very expensive. And so, just to give you an idea of how expensive probate court is, let's say that with um, there is a gross estate with a fair market value of $500,000. Okay, 490,000 of that is the home, right? It's what the home would sell for, not how much the home what it's actually worth. It's not the equity, it's what the fair market value is. And then $10,000 in various bank accounts. So a total estate worth $500,000. The statutory fees for that $500,000 estate is $26,000. Okay, $26,000 to go through probate court. And that's not the only cost. Right? There's other fees. There's filing fees. There's bond fees, publication fees, probate referee fees. That's another 2 to 3 thousand. That's almost $30,000 for an estate to have to go through probate court. Okay. If there are minor children involved, right, to receive any of this money, again, they can't receive money or through the probate proceeding until they're 18, which means anything they're going to be receiving is going to go to a court blocked account until they're 18 years old. And then at that point, they're going to get access to all of that money, which for, some life insurance policies and estates that I've seen, that's a lot of money for an 18-year-old to be able to have access to and not be financially responsible enough to be able to handle. Okay. Okay. Um, Here is a diagram of probate court. And if you are more of a visual learner, it's really just, having a will or no will at all, those assets then having to go through probate court. Um, Things that can avoid probate court would be if there's beneficiary designations like life insurance, investment accounts, retirement accounts, those generally would avoid. But what I've seen a lot of recently is people are not identifying beneficiary designations on those accounts, and then they're actually being brought into the probate proceeding because there's no beneficiary listed, and they want the accounts want a court ruling on who's to receive this money, and so we actually now have to bring those back in if they don't have those beneficiary designations. Okay, again, this is just a process that is. It can be stressful, and it's something that can be avoided if proper estate planning is done. Okay, one thing that I want you to think about is, what is your asset level at right now? If you own a home, the fair market value. If you have bank accounts, what are the value? Checking, savings, investment, bonds, stocks. Anything from an asset level, I want you to think about, what is that value? And you don't need to share it with me in the chat. Please just think about it, because we're going to come back to what that value would mean for you or for your estate if something were to happen to you, and how much it would cost to have to go through probate. Okay. Okay, so let's get into the planning documents. So these are 5 different estate planning documents that are critical when it comes to having a comprehensive estate plan: power of attorney, advanced healthcare directive, HIPAA authorization, a will, a trust, and guardian nomination. Okay, all of these things we're going to go through right now. So make sure to use that estate planning workbook you have. The idea here is that, you know, you're now starting to actually write in who you want in these roles, right? So that you are better equipped to now make these decisions to start that estate planning process. Over the years, I found people don't start this process because they can't figure out who they want in these roles. This is an opportunity for you to actually start writing it down using that workbook. The workbook, there's 2 spots in there. So if you're married, you have one for you have one for your spouse to be able to write your stuff. Keep in mind, this is not a legal document, okay? This is a workbook. This is for you to take notes. You actually do need to go through the process of creating all of this stuff, like working with us and creating an estate plan, signing the documents to have them be legal documents, okay? So just notes at this point for you to be able to work with. Okay, so let's start with power of attorney. So, a power of attorney is a legal document that gives your agent the ability to make financial decisions on your behalf if you are unable to do so, right? Going to the bank, going to the post office, filing tax returns, anything that if you didn't have that mental ability to, then they would essentially be able to step into your shoes and act on your behalf. Okay. A power of attorney in California, we have the ability to do what's called a springing power of attorney. So if you're in good health right now, and most of our clients that are coming through, they're doing this from a planning perspective, but they don't want to give anybody this power right now. Well, we can say, well, it's not effective yet. It's only effective and springs into effect upon some type of incapacitating event, right? Only if you were to become incapacitated would this power of attorney be able to come into effect. When you are identifying your agents, that you identify, generally, I would say one is your primary and then two as backups if you can. So for a total of three. If you're married, your spouse can be your primary, but they don't have to be. The biggest requirement here is that they are over the age of 18. But this is somebody that you trust, right? They're going to be able to have access to your money if you were to get sick. They're going to be able to be involved in all of your financial stuff. And so you want to make sure that you have somebody in this role that you trust. I don't want to get into DIY plans right now, but it's important to make sure that when you're going through this process, that you're doing the correct documents that are actually going to be the things that you need. If you've considered doing a DIY plan, maybe I'll say this as kind of questions for the end. I have a really bad story about somebody who did a DIY plan relating specifically to this power of attorney. And again, if you want to hear it, please, put DIY in the comments or in the chat, and I'll bring it up at the end, because it's just something that you need to make sure that these documents are valid legal documents, because that's when you're going to need them, is when you need them to be valid, right? And that's why they're so important. Okay, if you have any questions about power of attorney, please make sure to put that in the chat. And I will go on to the Advanced Healthcare Directive. Okay. So the Advanced Healthcare Directive is very similar to the power of attorney, but this is specific to those healthcare decisions. So identifying an agent to be able to make healthcare decisions for you if you are unable to do so. Without having proper advance in place, your family or friends, whoever you want making those decisions or being involved, could be blocked out of any information when it comes to medical information, right? There's a lot of laws that are surrounding privacy. And if you do not have proper directives in place, then your family may be shut out of being able to get information or make decisions on your behalf. Okay. In your Advanced Healthcare Directive, which is also known as a living will. Okay. And I know this is where it gets confusing. I've also heard it referred to as a healthcare power of attorney, but in California, we specifically call it an Advanced Healthcare Directive. And in this, not only identifying agents, but also having certain end of life decisions in there. Do you want burial? Do you want organ donation for transplant purposes, or none at all? Would you want prolonged life support with extreme measures, or would you want to be taken off of life support if you are in a persistent vegetative state? All of these are very important decisions and would be documented in that advanced healthcare document. Okay. When you are doing this in your workbook, under this, it is important, again, identifying that primary agent and two backups if you can. You can have your spouse there as your primary if you want to. You don't have to. The biggest thing here is just making sure that you identify somebody that you know is going to be able to make these decisions. In any of these roles, make sure that you're having a conversation with them and ask them first if they are okay being in this role, because they do not have to act if you put them in this role, right? They can just say no, they don't want to do it. So it's important to make sure that they are okay acting in this role. Um, and that they're okay making healthcare decisions for you, right? You know your important people in your life. So put somebody in this role that can actually make this decision for you. Um, what you're going to find as you're completing this workbook is that a lot of the people are going to be the same in all of these different roles, and that is totally fine, right? That's generally, like, that's the way that we see it. Is it's usually like three of the same people that are in these various roles throughout all of your estate planning documents, because a lot of the stuff is intertwined that they're going to be doing for you. Okay. Okay. I will also mention the HIPAA authorization here. And the HIPAA authorization is a document that kind of goes hand in hand with the care directive from a protected medical information, but it essentially allows you to identify people that you would want to be able to talk to doctors, get medical records, find out what's going on. And so in your life that you don't want making decisions, but you still want them involved in understanding what's going on, right? Being able to get that information. You can include them on the HIPAA authorization and not on the directive. Okay. Okay, if you have any questions so far, we've talked about power of attorney and advanced healthcare directive. You can put those in the chat. Um, I'm going to move on to the will. So the will is probably the most famous when it comes to estate planning documents, right? We see it on TV all the time. It's the reading of the will. Um, So, a will is a legal document in which you give certain instructions to be carried out at your passing. In your will, you say how you want your stuff distributed, right? Where do you want your money and your property to go to? It also allows you to nominate guardians for your minor children, right? Those are the two kind of big things that we do with a will. When somebody passes away, that is when a will actually comes into play, right? It is then filed with the court, thereby becoming that public record that we talked about going through probate court. If somebody doesn't have a will when they pass away, their assets are distributed according to California law. We call this intestate succession, and it's basically California's estate plan for you when you don't have a legal estate plan in place. So the biggest myth that I hear when it comes to wills is that having avoids probate court, and this is just not true, right? Um, Having a will is basically just telling the court, here's how I want my stuff distributed, make sure it's distributed this way. So if you hear somebody say that, just kind of think twice about it, because that is not true. That is not what a will does. Okay. Okay. For this part, between the revocable living trust and the will, which we're going on to next, it is going to be the personal representative or the executor, right? Those are the people that are going to be in charge. They're going to be the same people for these two roles that you're going to be identifying. Okay, so revocable living trust, also known as a living trust, also known as a revocable trust, also just known as a trust. All of these terms mean the same thing. And a trust is basically just an agreement. And it's an agreement between the grantor, which is the creator of the trust, and the trustee. The trustee is the person who agrees to hold legal title to all of the assets in your trust. And they will then follow the instructions in your trust for the benefit of your beneficiaries. And so while you are alive and you have a revocable living trust, you are also, right? You are the grantor, meaning you created the trust. You are the trustee, meaning you are in charge over all of the assets in your trust, and you are the beneficiary. All of the stuff is there for your benefit to be able to do with what you want, okay? You're not losing any access to any of the assets in your revocable living trust. It's only if something were to happen to you, that you were to get sick, right, become incapacitated, or that you were to pass away, that's when your successor trustee or executor would come in to be able to follow the instructions in your trust for your beneficiaries. So the biggest myth that I hear with trusts are that trusts are just for the wealthy people, right? I'm not Bill Gates level, I don't need a trust. But in the example I gave in the beginning, where the daughter had called because her mom had passed away, and they just had this house, right, that they needed transferred to her and her brother. That was the perfect example of where irrevocable living trust could have avoided probate court. And that house was worth about $800,000, right? It was just an average family home. And that they weren't a wealthy family. They were an average family that owned a home. And so having a trust in that situation could have prevented probate court. And so this is where trusts really are for everyone. It just depends on what you're trying to protect. And that's where having a trust can be designed to be able to have those protections in place. Okay. So some of the benefits of having a trust allow you to set up sub trusts for your children. So if you do have minor children, or maybe even young adult children, you can set up trusts within your trust that you could say, well, instead of them receiving money at 18, I would actually want them to get money at 25, 30, 35, right? Being able to protect that money and extend how they're receiving it, so it's going to be more protected for their benefit. Having a trust, you have the ability to create trusts where you can protect your children's inheritance from creditors, and divorce. What if your spouse gets remarried, right? Having specific protections in place with some type of asset protection, okay? When you have a trust, you get to choose the trustee to manage your finances. So maybe if you have minor children, having the guardian be the trustee, or if you have adult children, you can make them the trustee for your trust. But again, these are all decisions you get to make when you create your own trust. Private, no court involvement, which means less money that's going to be spent on fees, right? Because now if there's a trust, the goal here is to avoid probate court, which means there won't be those statutory fees that are going to be required to go through probate court. Okay. Listing your trust as a beneficiary. This is another really big one, especially if you have young children or children. So if you have a trust, you could say, instead of money going to my minor children, like through a life insurance policy, I'm going to, and listing my kids there to get money when they turn 18 through court, I'm going to list my trust as the beneficiary in my life insurance policy. Then if something were to happen to me, my money is going to, or that money is going to then go into my trust to be able to be distributed to my kids at 25, 30, 35, right? Or, whatever those parameters are set within your trust design to make sure that it's what you want, right? And I think that's really important. Okay, here is a diagram of kind of how a trust functionally looks, right? Having all of these different assets on the outside of the trust, kind of either pointing into it or named in the name of the trust. Again, this is your trust throughout your lifetime. And then it's only if something were to happen to you that's when it would be distributed, whether there's a surviving spouse, depending on how the trust is written, or just going straight to beneficiaries. Okay. Again, the goal here with having a revocable living trust is to avoid probate fees, which means less money that's going to be spent from the estate. Okay. If you have any questions, please make sure to put those in the chat. I am going to now go on to the last one, which is guardian nominations. So again, when we talk about guardian nominations, so children under the age of 18, we look at two things when it comes to guardian nominations: long-term guardians and short-term guardians. So when we think about long-term guardians, you want to choose a guardian that shares the same parenting style as you, right? They will provide the best love and support for your kids. This is the hardest part of estate planning if you have minor children. I get it. I am a mom with two young children, and it's something that you never want to have to think of. That's why it is so important, because this is your ability to have your voice heard, to have the guardian nomination completed, so that if something ever happened, the court knows exactly who you would want in this role. Okay. So long-term guardians and then short-term guardians. So short-term guardians, this is going to be more of, if you were out on date night, who could be to your kids within 30 minutes, right? This could be family or friends that are close by, that if something were to happen, here the goal is to try and prevent child protective services from coming into the home, taking the kids out of the home and putting them in foster care until somebody is able to get to them. So you want to make sure that you have both of those set up for those minor children. When you're looking at nominating guardians, again, having primary agent or primary guardian and then backups is really important. You also want to look at things like who has relationships with your kids? What are the ages of your kids? What are the ages of the guardians? Like if children and elderly parents, and you list your elderly parents as the guardians, are they really going to be able to keep up with your kids? And is it going to be a great lifestyle for your kids to have elderly, to have their grandparents who are elderly now have to take care of them, right? Is that the lifestyle that you want from both sides? So these are just kind of things to think about. If you nominate guardians that are in a different state, right, or your kid's going to have to relocate. So all important things to consider for your minor children. And again, without any guardian nomination, a judge who has no idea about you, about your family, about your situation is going to make that decision without you. Okay, so that is why it is so important to have that. Okay. All of the documents that we've just talked about make up a complete estate plan, right? It's not just one of these documents alone, it's all of them together make up a comprehensive complete estate plan. Guardian nomination, will, HIPAA authorization, a trust, power of attorney, advanced healthcare directive. All of these come together to make up a comprehensive estate plan, because without it, and I see this. People think they only need one thing or two things, and they come to them, and we look at the documents and we say, I'm sorry, but you needed this power of attorney, and you only had a will and a HIPAA done, right? And it's because they're not putting all of the pieces together, right? And that's why it's all of these. The documents, they all have individual things that they do, which means you need all of them for that protection. Okay. Okay, so something to think about. Do you think you might need some type of estate planning documents in place? Right? Yes, absolutely. Anybody that is over the age of 18, but especially if you have minor children and or own a home, you need to have some type of estate planning documents in place. So I am going to, as I kind of start wrapping up here, I want to go through the services that we help you with to make sure that you can put your plans in place, giving you the peace of mind that you deserve. Okay. Let's talk about our basic trust package. This includes a basic revocable living trust, a pour over will, power of attorney, advanced healthcare directive, HIPAA authorization. We do a trust certification, estate planning summary, and a general assignment to your trust, personal property memorandum. We have memorial instructions and funeral wishes that's included in there, as well as a trust funding toolkit. Okay. In addition to the basic trust package, we also have where you will have 2 virtual meetings with an attorney. You will have a phone, client portal, and email support from our team to help with any questions or guidance that you need along the way as you're doing your estate plan. If you have a primary residence, we are going to prepare the grant deed to transfer title from you to your trust. And we're going to get that recorded. We're also going to complete the assessor's form to make sure that the house isn't going to get reassessed, which is really important to make sure that you keep that property tax basis that you're at. We're going to get all of your documents signed with a virtual notarization. We will give you an estate planning portfolio that's going to have all of your estate planning documents in there with a USB drive that's going to have a scan of all of your documents, because it's important that you are able to save all of those documents, put them up in the cloud, put them somewhere safe. You're probably also going to want to or need to send your trust certification to different companies that you work with, vendors, insurance agents, things throughout your life. And so you'll have those all on a USB drive for you to be able to easily access. A trust funding toolkit, so you know how to fund your trust throughout the course of your life, as well as workshops and events that we put on as part of the firm. Okay. Okay, so how much does estate planning cost? So everything that we do from an estate planning perspective is done on a flat fee basis. Our trust packages start at $4,495 for a single person and $4,995 for a married couple. For watching this webinar with me today, you do get a discount for attending. So it's $500 off a trust package. So what that means is a single person can get that for $3,995 and a married couple for $4,995, which is a really great deal because it comes with all of that stuff that's included in that basic trust package. As I wrap up, there's just a couple things I want you to think about when it comes to the price. I know that estate planning is not cheap. It's not a cheap process, but think about by not having it, the things that could cost you or your family having to go through. And so let's think about if you were to get sick, right? The documents that you would need would be a power of attorney, advanced health costs. Those are all things that come in that basic estate planning package for that, $4,000 package. Without having it, it would then cost you or your family six to $10,000 for a court conservatorship. And so by not having that estate plan, this is the money that it would cost. If something were to happen and your family needed to be able to access bank accounts or sell the house or refinance the house or do something from a financial perspective that they couldn't do because you plan done, right? That's where that conservatorship comes in and costs somewhere between six to $10,000. Okay. The other side of that is if you were to pass away, right? That $4,000 estate planning package is nothing when it comes to probate fees, right? It's comparison to how much probate fees can be. So remember when I asked you to think back to what your asset level is at right now, right? The fair market value of your home, checking account, savings, investment accounts, things like that. So $600,000 house or a proper estate, right? Whatever it's made of, $30,000 in statutory fees, an $800,000 estate, which is the median price for a home in California, is $38,000. $1 million estate is $46,000. $1.2 million is $50, and $1.5 million estate is 50. So I have some people, they've come to us and they're somewhere in the 1.2 to $1.5 million range as they're coming to these. And say I have a primary residence and I have a rental property. $50,000 is so much money compared to having an estate plan done for less than 5,000. Exactly it. Right? The small amount of money compared to how much the statutory fees are, it's just it is. And what people have told me is, why wouldn't people do this, right? To be able to not have the estate pay. Because what I'm seeing is that when families don't have an estate plan and we have to go through probate, the family that's now having to take the estate through probate, maybe where there's just a house, they can fees. So they're actually having to sell the home to be able to pay for the house to go through probate, right? And that's not what was intended. That's not what they wanted to have to do, but they don't have the money to be able to come up with this. This isn't including the filing fees, the bond fees, the probate, additional money that gets added onto the statutory fees. Okay? But it's not just about the money. Think about the burden that you are putting on family and friends to do this process and have to go through this without having any legal documents in place. I will never forget a call I had with a client. Her mom had just died. And as I'm talking to her, she said, I'm so angry. I'm so angry at my mom for not doing any of this stuff, for not having her estate plan in place. So now all I have to do is make these decisions, fill out paperwork. My mom just died. Right? And so this burden that facing of having to make all these decisions and do all this paperwork because mom never did it was huge on her. And she just wanted to be sad and she couldn't do it. So by doing an estate plan now, you're taking that burden off of those family members, right? You're making it easier for them so that they can now have that time to grieve and not have to do this paperwork. Okay. Okay. So let's go through what our process is as we wrap up here. So for our estate planning process, the first thing you're going to do is you're going to book your family planning appointment. I'm going to refer to it as an FPA here. We're going to send you an email with an online worksheet for you to complete, and you're going to get that submitted online. Then you will have a virtual family planning appointment with one of our attorneys. During that family planning appointment, you will design a plan that fits your family's needs and ensure that whatever those wishes are that you have are documented. And then you're going to sign your estate plan about 4 to 6 weeks later. Okay, that's kind of what the process looks like from our estate planning perspective. So to get that workshop discount, that $500 off, let me go through what the requirements are for you to be able to get that discount. Okay. So what you're going to do is you're going to pay the family planning appointment fee today. It is $349 and it is non-refundable because as soon as you book this family planning appointment, we are now starting work on your case. We're going to start sending you the information, go through sheets, start pulling deeds, figure out what we need to start working on your estate planning file and be able to have that meeting with the attorney. Okay. The second thing you need to do is when you go to pay that fee, you are going to be scheduling your virtual family planning appointment with the attorney at that same time. Okay. It's going to, when you see that calendar with that schedule, you click the day and the time that you want, and it's going to ask you to confirm your information and pay that $349 fee. Okay. To get this webinar discount, you need to get this completed within the next 3 days. Okay. That is the requirement for you to be able to get that $500 off. And then the family planning appointment, it could probably be about 2 weeks out. You can get it sooner if there's availability. That's generally what we see is what that turnaround time is going to be. Okay. And then only then will that estate planning fees be due at that family planning appointment. What I will also say is that, if you are single, your fees are going to be $3,995. That $349 is not in addition. It's going to go to the cost of your estate plan. Okay. So it's not additional money. It just goes towards the cost of what that plan is. So you will owe less money when it comes time for that family planning appointment. Okay. Okay. I am going to put a link here that if you found value in this webinar, I would appreciate you leaving us a review. I will also get this sent to you in an email that's going to be sent out to you after this. But it's really important just to let other people know what it's like, right? If you learn something, to share your experiences. Other things to keep us in mind for outside of estate planning that we help with is if somebody passes away, we help families figure out what those next steps are and help them through the process, whether it's probate court, trust administration. Sometimes there's property issues after somebody's passed away, and it's trying to work through those. Okay. If you are ready to book your family planning appointment and get that $500 off your trust package, I'm going to put the link in the chat there for you. This is going to be the first step for you being able to book that. So make sure to click that link to go in and schedule your appointment and to get started. And as I mentioned at the beginning, if you stayed until the end, we do have that free advanced healthcare directive for you. So I'm going to put that link in the chat as well. And don't worry, we will get these sent to you in an email just so that you do have access to all of this. But if you didn't sign up for this and you're joining us live, please make sure to get that free advanced healthcare directive because you will not get an email for it. So make sure to click the link to get that free advanced healthcare directive now. Okay. At this point, I am done, and I want to take time to go through some questions that I've seen come in the chat. I do want to thank you so much for joining me. I hope that you found value in this webinar and that it really answered some questions for you on estate planning, whether it's for you or if it's for a member or friend. Everybody needs something when it comes to estate planning. And so the knowledge that you've gained today is things that you can now help to be able to share this information with them and make sure that they have those legal plans in place. Okay. Okay. So if you have questions, again, please put those in the chat. You are free to leave now if you would like to. But again, I am going to go through some questions now. Okay. Let's see. First question. Do I need a will if I have a trust? Okay. Great question. So because in our plan, we obviously have a will and a trust. So yes, you do need both. And the reason for this is we do what's called a pour over will, and they kind of work in conjunction together so that if something were to get left out of your trust, right? Maybe you opened a bank account or even bought a house after your trust was created and you never put it in that in the name of the trust, then the will, what we would call a pour over will, would tell the probate court, okay, well, we don't need a full probate because we just have this one asset that's left outside of the trust. we're just going to pour that into the trust, right? It's a pour over fund. We don't want to put any private information in the will about who's receiving what accounts you have or what assets you have. So it's just going to just pour it over into the trust. So that's why having a will and a trust that are able to work together in that pour over function are really important. And I say that, and I don't mean, okay, you just need to have a will and now you can get a trust, is they have to work together. It specifically has to list the trust in there. And that is very important to be able to have it function like that. Okay. Okay. If you did not get the link here, I'm going to put that back in there as I'm going through these questions. To make sure to get your family planning appointment scheduled. So that is the link is in the comments there. And again, I'm going to go through questions. So next question. What happens if I own property in another state? Okay. So this comes up a lot, and a lot of times people don't really think about this from an estate planning perspective. So, um, let's say if you own property in another state and you do not have any estate planning documents in place, what generally your estate or your agent that would be working on your behalf if something were to happen to you would have to file a probate in every state that you own property, right? It's not just everything comes together in one state and it's done through there. And so we do this for out of state attorneys we work with, that they have clients that they're working on a probate in one state and they own a property in California. So now we're doing an ancillary probate in California specifically for that property they owned here, right? So it's statutory fees in every state, right? Or whatever the other states, however their fees are done, statutory fees in California. Whereas if you have a trust, right? You have this comprehensive estate plan that we put together for you, and you have a trust, well, you can then say, well, I have all of these properties in these other states. Let's have the deeds transferred from those other states to me in the name of my California trust, right? It works. And so now if something happens to you, your trustee can now just administer with the properties in all of the other states. Okay, makes it so much easier with rather than having to go through all of those different probates. Okay. Okay. Next question. Can I just add my adult children to title of my home rather than get a trust to avoid probate? Um, okay, so I'm going to give you 4 reasons not to do that. Um, and you can make the decision on if you think that's best, right? So again, it's adding an adult child to title of a home rather than doing an estate plan. So first thing, if you add somebody to title to your house, not a spouse, so let's just say adult child for purposes of what we're talking about here, there could be a reassessment on your property taxes. And maybe it's on a portion or all of it, or the assessor's office makes a mistake, and then you have to pay that money and then fight them, and then maybe get the money back a year or two later, right? So there could be reassessment. So property taxes could go up. Second, what if your kid gets in a car accident and they don't have insurance coverage to be able to cover the damage to the other party? And so now they're going after assets that are owned in your child's name, which is your house, right? They can come after your house. A third thing, um, what if you and your kid are not getting along, right, at some point? And I see this, unfortunately. Or at a point that maybe you want to refinance, maybe you want to do, a special refinancing. I can't think of the name of the type of mortgage it is right now. That when you're older, right? And your kid doesn't want to sign off on it, or you want to sell your house to go into, a facility of some sort or downsize, and they don't want you to, right? If they are listed on there, they have just as much right as you do to not sell your home. And I have seen this happen on multiple occasions. The kids will not sign it once parents add them onto it. The last one that I'll mention is you lose the step up in basis, right? And what that means is that when you bought your property, let's say you bought your property in 1980, right? And you bought it for $100,000 in 1980, and now the property is worth $1 million. So there are capital gains from that $100,000 to $1 million of capital gains of $900,000. If you add your kid to title now, then they are inheriting that $100,000 tax basis, which means that if you pass away and they go to sell it, they're going to have to pay capital gains taxes up to that $1 million price now. Okay. Whereas if you have a trust and you say, I want my kid to inherit my house when I die, then they inherit the money at that $1 million when you pass away, if that's what the house is worth, it thereby gets that step up in basis, and they do not have to pay capital gains taxes on that $900,000 that has been earned over time. Okay, that's a huge benefit, and a lot of talked about when just adding their child to title to try and avoid probate court or avoid having to go through estate planning. Okay, hope that was helpful. Okay, let's see. I have time for just a couple more questions. And again, if you have not already done so, please go get your appointment booked for your family planning appointment with one of our attorneys to get that $500 off the estate plan for your trust package. The discount, again, does expire in 3 days. So make sure that you get that booked to be able to get that discount. Okay. Okay, next question. If something happens to me, won't all my stuff just go to my spouse anyways? So this is a really this is one I hear a lot from people is that like, oh, I don't need it. I don't have that much stuff and everything's just going to go to my spouse. Well, that's not always necessarily true, right? It really depends on how the assets are held, whether, if you own a property, if you own it maybe you owned a house prior to marriage. So it's your separate property, and maybe you have a blended family situation where you're now married and you have kids from a prior marriage. Well, in that case, that house that was your separate property and that you thought was just going to go to your current spouse, if it has to go through probate, it's going to go through that intestate, right? Succession that estate plan California has for you. And in this case, if you have one child and you have your spouse, then their spouse will inherit half and your one child will inherit the other half, right? If you have two kids and you have that one spouse, then that one spouse will inherit a third of the house and the two kids will inherit two-thirds, each getting a third themselves, right? And so it doesn't automatically just go to your spouse. It all depends on how title is held. So that's why estate planning is so important, because then you can go through and figure out, okay, what are the assets? How do I need to do to make sure that this is the plan I want and this is how I want the assets distributed, right? And then making changes to be able to accomplish that. Okay. Okay. Looks like I have time for one more question. Let's see. Okay, I see two questions. I like both of them, so I'm going to try and do two and then be done. Okay. Okay. So rather than get an estate plan, can I just put beneficiaries on all my accounts in my house? Well, we just talked about the house one, so I think you know that doing that is not the best. There are, California. I don't want to tell you the name of it and go Google it and try and do it. But it's called a transfer on death deed. And where I've seen them, they don't the way that they're supposed to, and it ends up costing way more money than just doing a estate plan in the beginning. The point I'm trying to make with this question is if you just put beneficiaries on your accounts, bank accounts, checking, savings, investment, retirement, beneficiary designations only they only receive the money when you die, which means if you were to get sick, right, or you needed to go into an assisted living facility and you needed to sell the house, somebody needed to be able to access your bank accounts. They wouldn't be able to do that if you were sick, right? They only get access to the money when you actually die. So it's not allowing anybody to have access to your stuff. Having a trust And having your bank accounts in the name of your trust would then allow your successor trustee to step in and be able to access the bank accounts, be able to take care of any medical bills or, nursing care costs, or sell your house, right? But they can't do that if they're just listed as a beneficiary. They can only take action once you die in this example. Okay. Okay, last question I want to get to, because I think this is another really important one. What happens if I buy another home in the future? Do I have to pay more for my plan? When you have your estate plan done, it is your estate plan. You have your certificate of trust, which means that you go to buy a new home in the future, you provide that certificate of trust that we give you on your USB drive. You provide it to title and you say, I already have a trust, just put the house directly into my trust, right? So now when the closing on your house, they're just putting it directly come back to us to make any changes or to add anything that's going to cost you any more money, right? So you just need to make sure that you tell them, put it in the name of my trust. You have all the ability to do that. Same thing if you want to sell your house, right? You have the documentation, you just sell it as the trustee of your trust. You don't have to come back to us to be able to do any of those, the house sale or buying a house or selling a house in the future. Okay. Okay. Thank you so much again for joining me today. I hope that this was valuable for you. Great questions. If you, again, have not already done it, please click the link to schedule that family planning appointment. Again, you have 3 days to be able to get that discount, to get that $500 off for you to be able to get started. Because again, it's so important, right? Estate planning is so important. The peace of mind that you get by signing that last document is just, it's the greatest feeling because you have those plans in place and you know that it is done correctly. So thank you again for joining me.